if we reach the merits, I don't want to repeat myself, the legal representations and so on and so on. Given that the egregious nature of those violations, in any event, this is not a case where you can say, I've already discussed that it has practical effect. But even if it didn't have practical effect, this is a case where, because of the 172.1a nature, and that goes directly to your question, of the cause of action that was ignored in Cape Town, you are free to overlook, quote unquote. Now, I use the word overlook advisedly, because this is what I've been trying to say, the overlap between this issue of mootness and the entire appeal. I'm going to argue that you are entitled to overlook both mootness and ripeness, right? Which is what the appeal is about on the merits. But when I say that, I'll be saying that based on the very same principle called the Gijima principle. So the direct answer to your question is that this court does not have to go so far to say, if you have a 172.1a, you may never be non-suited for mootness, delay, ripeness, the usual constitutional technical points that get taken. We're not requiring you to go that far. And there's no need in this case. And we are salvaged, as I say, by the egregious nature of the self-evident breaches.
So we can accept then, because there are a range of matters in the Constitutional Court where that court appears to embrace the jurisprudence of this court when it comes to the question of mootness.
Yes, including the one where you found in my favor, which was Makidiwana. If you remember, Justice Ponan, in that case, I was on the other side. And you raised this point and said to Mr. Marcus, who was my opponent, isn't this moot? Because in this case, the Marikana workers have already been paid. And we were out of here within an hour or so. Then the other side, Legal Aid, I think was my opponent, went to the Constitutional Court. You'll remember that's the 2013 Magidiwana case. What that court said on a split of 10-1 was that it upheld your formulation. And that was because in that case, that court said these were so-called context-specific issues. And that's I'm in a way discussing the same principle, except Justice Nkabinde, who dissented, said you were wrong because the thing was not moot, it was still alive, and so on and so on. In fact, her judgment is much longer than the other one. It's a good judgment, but unfortunately, she was alone. Fortunately for me. Now, and you've hit the nail on the head, Justice Panna, because the debate that is raging in academic circles about the Gijima principle is exactly what you're saying. Does this now mean that you can bring a 172.1a application 20 years, let's exaggerate, undue delay, obvious undue delay, but simply because you are vindicating the Constitution, the court must give you relief? I don't know what the answer is, but my respectful submission is that this court doesn't have to go that far.
Okay. The second issue that I want to raise with you is this.
Mm-hmm.
Would we be issuing, if we are with you, would we be issuing, in effect, the sort of order that was sought in the court below, or would we be issuing some other order which a la Section 172, which would be sort of
just and equitable,
which would be declaratory orders that are not strictly confined by the relief that was originally sought.
Okay.
Because I mean, your debate has taken it, has moved it along a little, and I'm just wondering, what the logical flow of the debate would
understand. No, I was going to say on a lighter note, next time we won't allow you to go to tea, just this panel. Now, these questions are both difficult, but go to the heart of the matter. Actually, after answering that question, I should just sit down, because that really goes to the heart. What we are asking this court to do is, let's call it maybe threefold. The first is to say the obvious, that which I said before tea, that this court misdirected itself, to put it politely, in dealing with one cause of action and completely ignoring the other cause of action. Then comes the million-dollar question that you're asking. If you could do, no, it's not three, it's four things. You could just do a declaration, 172(1)(a), which you must do.
What form would that take?
No, that's the simplest order. I can draft it now. It simply says that the following conduct, XYZ, whatever it is, the conduct of XYZ was inconsistent with the Constitution. That's a pure 172(1)(a) conduct. In other words, the fact that there was a denial of legal representation, the fact that there was a member who was conflicted and so on was in violation of the Constitution. Simple, everyone knows that. And so that's the first thing. The second thing you can do, of course, I almost said I'm dodging. I'm dodging the primary question. The primary question is whether you remit or deal with the matter, but that's a different question. Let's park that. The next question would be, as you correctly say, a 172(1)(b), because that's where you now have a discretion. You no longer have a gun pointed at you where you must declare. Now, 172(1)(b) says you may grant just and equitable relief, which we've asked for in one of the prayers that we were looking at. Now, and that's really the heart of your question. That, in my respectful submission, we're going to say, in that rubric of 172(1)(b), first, let's look at what the Western Cape Court should have done. The Western Cape Court should have followed this court's binding precedent in two cases, Jantyi and Dube. I call them the two Ds. In Jantyi, and again, this is just my own shorthand because I'm not going to go through that long list of transgressions. So I'm picking one for shorthand. The logic is this: if this court is not prepared to find that the closing out of lawyers is a violation of the Constitution, then it will find nothing to be a violation of the Constitution. So I don't have to take you to all those other 15 things. If that is not sufficient for any lawyer, that a legal representation, which, by the way, has been granted by the Constitutional Court after litigation, as full legal, and then somebody decides, no, I'm going to deny you that. If that is not enough, then nothing ever will be. So that's the Jantyi case. The Dube case then deals with the issue of Mr. Mileham. The Jantyi case deals with the chairperson of the committee and the committee itself. The Dube case, you will, I'm sure, will all remember, if I remind you, deals with the Mileham situation. Now, again, with Mileham, I'm not going to go into all those things about the tweets and what have you. I'll just pick one. And I say, if this court is not prepared to accept that it is a gross violation of human rights for somebody to be tried by a panel of judges of whatever, in which one of the judges, quote unquote, or decision makers, is married to the complainant. If the court finds that that's not a violation of the Constitution, it will never find anything to be a violation of the Constitution. So I don't have to go through. So that I'm going to confine it to those two most egregious violations. Now, what did the court do in Jantyi? Which is what that court would have done if it hadn't mistakenly avoided the merits. In Jantyi, the facts were almost exactly the same. In fact, our facts are better. And that is the case of, Minister, I'm so sorry. Jantyi, not that Jantyi was chairing the, Jantyi, this one was a university student. Yeah. Jantyi versus Rhodes University. 2023-1, SA 32. This was, in the Western Cape, this was what we call a lawyer's dream. Because this came out in January of 2023, and we argued the case in February. So it was hot off the press and unanswerable. But the court somehow managed to find a way around it. So this is what happened in Jantyi. Almost the same facts, I can assure you, because I was there. So Mr. Jantyi is being represented in this, Ms. Jantyi, sorry, is represented by an advocate and an attorney, I think 2 counsel and an attorney in a DC.
That's the Rhodes University matter.
Yes, the Rhodes matter, yes. Then she is, the advocate is not available for some reason or another. And then the initiator, I think that's what the proctor, something like that, whatever that means. Yeah. But the person in charge then says, okay, well, I don't care that your advocate is not here. Your attorney is here. And is a lawyer. Let's get on with the show. Then she obviously takes that to court at the end of the case, and that's why the court mixed up the things. This court, of course, said in Jantyi the proceedings were not in medias res, but that had nothing to do. We're not presenting this case for that. We're presenting this case for the merits, for the denial of legal representation. Anyway, this court said, per Van der Merwe J.A., that you can't do that. You can't say your advocate is not here for good or bad reasons, and I'm just going to proceed, which is exactly what happened in the current case. It happened on the 13th of September. It happened on the 27th of October. It happened on the 1st of November. It happened on the 2nd of November. But even if it had happened for 5 minutes, in my respectful submission, it would be an egregious violation of human rights. So the court in Jantyi said, you can't do that. You have to, and that comes to your question, Justice Panel, was setting aside the finding which was made against Ms. Jantyi, and we are, in that case, because it was what Cape Town should have done, we are remitting it back to Rhodes University, but they must have a different proctor, chairperson, whatever you call it. That is the typical order that is given. In Dube, the same order was given. In Gedezi, the same order was given. There's another case, I think in Cape Town, I forgot. But that's the long answer to your question. So what really should have happened is that those judges should have said, go back, minus Mr. Mileham, who is obviously conflicted, and the DA, if it wants, I suppose, could have substituted him and put somebody else. Why is that so? Oh, no, let me not jump to Dube before we finish with Janji. So in Janji, this court said, at paragraph 25, Ms. DeForce and Mr. Makhalemela represented Ms. Janji, I suppose those were the advocates, over the 12 days of the disciplinary hearing up to 11 October. The transcript of the proceedings up to then came to 700 pages. Let me pause there. That is, compared to, our transcript was at 60,000 pages. And then says, in such circumstances, the role of the instructing attorney is usually more of an administrative and logistical nature. There was no reason to believe that this was not the position in this matter. Thus, the ruling of keeping the advocates out deprived Ms. Janji of the services of two counsel steeped in the matter. Exactly what happened here. Moreover, they did so at a crucial stage of the proceedings when Ms. Janji was about to testify and to present a case. The suggestion of the university, or in this case of the government, that Ms. Janji should have proceeded with only the assistance of Mr. Mdabe, in our case it was Mr. Sianejo, and the candidate attorney was quite unreasonable in the circumstances. It would have been difficult to obtain the services of counsel willing to act pro bono and able to properly prepare within the 10 working days and so on and so on. This caused prejudice to Ms. Janji that could only have been justified by powerful considerations. That was especially so because this could have been avoided by the simple expedient of setting down the matter on another date. Exactly the same here. Because
so what's your answer to the question is what order should we make here?
Well, I've just said the order that should have been made in the Western Cape.
Which is remittal.
Yes, which is, no. Remember, let's not mix two things. There's the remittal, which was done here, to roads, right? So that would be a remittal to the, Section 194 committee. You can't do that. It's gone, yeah. So there's another remittal with capital letter R, let's call it, so to distinguish it from the other remittal, which is called for now because you are this court has been placed in the unfortunate situation where the court in Cape Town has not dealt with the merits, which it should have on the principle of S versus Jordan, even if they found against us on ripeness. They should have decided the merits so that this court doesn't now have to be saddled with the merits. So that's another huge misdirection just on its own by that court. So you have now a burden to make a decision, if you are with me, whether to set aside or rather to declare, to give my declaration in 1721A simpliciter, or to remit the matter back to the Western Cape Court, which didn't do its job, to say it must do its job.
With what ultimately in mind for the Western Cape Court?
Yes.
Because I mean, assuming they were inclined to further remit,
yes,
as you say, there's no Section 194 committee.
Yeah. That remittal, Justice Panel, would have been in terms of Section 172(1)(b, all right? So I'm saying before you go there, you have to deal with the 172(1)(a, all right? So if you remit it to the Western Cape High Court, which failed to do what it should have done in terms of S. Jordan, all you'll be saying in simple English is that that court must not do what it says it did at paragraph 58 of its judgment, which is astounding. At paragraph 58 of its judgment, that court says with, don't know what to call it, frankness, maybe if you want to put a positive spin. It says, it is not necessary. It says, having found that, let's start at 57. Oh, sorry, you'll find that in the core bundle at page 20. Thank you. This is what that court did wrong, like, as I say, it says, we thus have found, had the application not been determined on the basis of the relief that had been sought in medias res, and accordingly that any review, underline the word review, so they were only deciding the review, not the declaratory. Any review of the matter is premature, which for present purposes, let's say that was correct. Yeah. That any such review would be undertaken against the principle of legality and not under parja. True, we concede that. Well, we concede it for the purposes of today. I don't want later to be held to that concession if the matter goes to the Western Cape or to the... That concession expires at 5 today. So let's assume that we say it was not parja. Then that court then had a duty to then examine the review under legality. It failed to do so. That's a huge misdirection already. Then we go to 58, which is this is the one that takes the cake. Then they say, it is also not necessary, given our finding that the applicant has sought relief in medias res, to determine, in other words, to decide. 1, the test for bias in proceedings before the committee established under Section 194, and whether a case for bias has been made out against either the chairperson or Mr. Milham. How can that be? How on earth can that be? That because you have found against me on review on a particular cause of action, which, as I say, I concede for the purposes of argument, that therefore it now suddenly becomes not necessary for you to look into the next cause of action of legality and of whether there was indeed violations of my rights. And 3, they say, whether the issues complained by the applicant concerning inter alia, the widening of the scope of the inquiry, and the violation of her rights to audi alteram partem have merit. How on earth can it not be necessary to look into those causes of action? So that's it should offend the sensibilities of anybody who is seized with a matter of this kind. For a court.
Mr. Mpofu,
Yeah, Justice.
To that question you raised,
Yes.
not found in paragraph 47.
Yes, thank you. In fact, the big paragraphs in this whole judgment is 47, 57, and 58. Thank you. Let's go there, Justice Moore. So you'll see a big note under next from me, next to 47, which says gist. So, yeah. So this is what they say in 47, which is completely out to lunch, with respect. So the applicant contends that gross irregularities, remember, Justice Butle, they are now addressing the Wallhouse test. Mm-hmm. So they are addressing, remember, the Wallhouse test says that in a review, please underline this, review, not a declarator. In a review, let's say from a magistrate's court, the court, the higher court, will only intervene if there's grave injustice or irreversible harm. I'm paraphrasing. That's what it says in reviews. Then there's another set of cases. Please forgive me, I'm also killing two birds with one stone. The other set of cases that they relied on relates to appeals. So that rule, the in medias res rule, applies to reviews and appeals. That's our submission, not to the alternative causes of action. The Sakau, Take and Save, and all those cases, Masangani, and so on, all the cases that this court relied on will either be dealing with an appeal or a review. So keep that in mind. Now let's hear what they say about the review. They say the applicants contend that gross irregularities have occurred in the course of the committee's work that are of such a nature that it is, quote, indisputable that grave injustice would result, which, as I say, I don't think anyone is going to argue otherwise, where the relief sought not to be granted. Yet she has pertinently not engaged in how her temporary lack of legal representation placed her at an irremediable disadvantage in circumstances when adjournment, in fact, eventuated after the medical certificate was considered. I'll show you that that's a complete, I don't even know what to call it. It's got nothing to do really with the case before you. Or how the alleged misrepresentations made by the chairperson and Mr. Malhan in the public domain grossly impeded her ability to continue presenting her case. That's again a sanitization of our real complaint about Mr. Malhan. It's got nothing to do with his so-called misrepresentations. The issue is, was he conflicted as a spouse or not? So they elide that as well. And then they say, in addition, considerations of time wasted and expense incurred do not warrant a different conclusion, including, I don't know what that means, including that we were informed by her counsel that the transcript was 60,000 pages. But that's a point in our favor. So, on the Janchi test. So, you're quite right. If this case was, let's assume, forget about the so-called alternatives. Let's say this case was purely a review. Then, if it was purely a review, there was no alternative cause of action that has been pleaded, then this finding would have simply been based on 47. But I'm in a good mood. So I'm saying, assume 47 is right. It's completely wrong, I can assure you. But assume it's right, and assume it's a good basis to dismiss the review. Then what? What then entitles a court to say, because of that, I'm not going to look at your alternative causes of action? What? There's nothing. There's no court in this country or any country that is entitled to do that. So, which is what they say at 57 and 58. Sorry, Justice Smith.
Yeah, so the question posed by my brother presiding, if you were to refer this matter,
right,
in your view,
if you're to remit,
yeah, to remit,
yes,
what would be the purpose of that? What do we expect
yes,
the court, our court, to do?
Yes. I've answered the question. I would expect that court to vindicate the Constitution in terms of 172(1)A, which it failed to do. That's the first thing I would expect them to do. Okay? The second thing I would expect them to, that one I wouldn't expect to do. They must do it. They have no choice. The Constitution says they have to do it. So it's not optional, whether I expect it or not. Then the second thing goes to 172(1)B. Well, firstly, I'm sorry, Justice Smith, they would have to entertain the legality review, which they say is available themselves in paragraph 57. They failed to do that. Then they would have to give us a 172(1)A declarator of constitutional invalidity. And then thirdly, they would give, which comes back to Justice Ponan's question, they would have a discretion, which in my respectful submission, they would have to exercise to grant just and equitable, any just and equitable relief. Now, the question I'm asking before you ask it to me, assuming that those other two orders are not controversial, what would be the nature of the just and equitable relief? Now, what we say is that they would have to say that, now because the events have, if it was still that time, they would have had to remit it, as I said earlier, to the committee without Mr. Mailam and maybe without Mr. Janji. But now that cannot happen, or that's water under the bridge. What they can then do is to say that the proceedings up to the point of February or March, I can't remember, up to the point of February or March 2023, yes, which is when we approach the court on an urgent basis, that those proceedings up to that point were null and void. And that's what Janchi also said. Janchi said that sorry. I'm sorry. You'll find that at paragraph 33. It said the appeal is upheld. That's obvious order. Then it says the order of the court of call is set aside. That obviously also must happen. And replaced with the following. So that would now be the 172(1)(b) part. Quote, the decision of 10 October 2017 convicting the applicant of charges of kidnapping, insubordination, and defamation is reviewed and set aside. How do you apply this here? The decision, remember what we've brought here, the decision of the Section 194 committee dismissing the recusal application, which was sometime in October, I can't remember the exact date, I think 17th October, if you look at the notice of motion. Sorry. I'm so sorry.
It is the 17th of October.
Yes. Decision taken on the 17th of October is set aside. So that's number, if you use the Janchi order. Okay? Then go to B, then Janchi says the decision of 1727 sanctioning the applicant by permanently excluding her from the first respondent is set aside. Okay, that may or may not be relevant. The matter, this is the important part, the matter is remitted to the first respondent for reconsideration on condition that any continuation of the disciplinary inquiry against the applicant shall take place before another proctor. In other words, not the biased one. Oh, that's obvious. Yeah. And then the first respondent is directed to pay the applicant's costs, including costs of two counsel. Mind you, that in Janchi, that's why I'm saying our facts are better. In Janchi, the real complaint was just Audi, the denial of the legal representation. In our case, we complain about all the rules of national justice, Audi and bias. So obviously it would have to be a different.
In that matter, though, remittal was possible.
No. With the small letter R, the remittal to the university.
That's what I'm talking about.
Yes, not the remittal we're discussing now.
Okay, well, let's just go to your notice of motion. Page 2.
Yes.
Let's just look at paragraph 4.
Sorry. That should be volume 1. Yes. Paragraph?
Paragraph 4 of your notice of motion.
Right, yes. I'm sorry. Yes, I got it.
Yeah. Would any of that still remain as live issues?
Would it remain what?
As live issues. In other words, can that be...
No. Oh, I'm sorry. No, absolutely not. No, that's what I should have said as I stood up. Yeah. No, the so-called substitution relief is gone.
Okay, so paragraph 4 is gone.
Yeah, no, absolutely.
So essentially, your complaint is that the High Court did not, in circumstances where it should have, entered into some of the other relief that had been sought.
Yes, let's start at paragraph 2.
And that would primarily be
2.
Insofar as paragraph 2 is concerned.
Yes, 2, and then paragraph 3, and then jump 4, scratch 4, and then paragraph 5, which is what we're discussing now. Paragraph 5 is the 172.1b relief that we've been discussing. So 2, 3, and 5, and 6 obviously costs would remain. Yeah.
If what's contained in paragraph 4 is academic,
Right.
and we accept that,
Overtaken by events. Yeah.
yeah, why is it that what's contained in paragraph 2 is not academic?
Because those two are two different animals. Relief under 172.1a and relief under 72.1b, which is what substitution is, are completely different juridical animals, right? The substitution or remittal or whatever is the usual. Any review that comes before any court is susceptible to either a remittal or a substitution.
Yeah, but hold on. I mean, if in effect what's going to happen is merely an order setting aside these decisions, the
Right.
recusal decision,
Yes,
the adjournment decision,
yes.
and
The witness
the
decision.
witness decision.
I think we called it, yeah.
Yeah, the witness decision.
Yeah.
Okay, so if in fact
You nullify those.
what the effect of the order would be is to set aside those decisions.
Yes, and nullify them.
Yeah, I mean, where does that take anybody?
It takes, well, if anyone includes Advocate Wisisiwe Mkhwebane, who is
Yeah.
before you, it takes a very, very, very far. And here's how. If indeed, and I don't know if okay, let me do it. If any human being is impeached.
No. I've heard some of the submissions relating to that, but I'm
Yes.
tying it up.
Yes.
I'm tying this question up to what's contained in paragraph 4. In
Yes.
other words, what one's going to have is a declarator in the air, so to speak.
No, there's no such thing. That's the point. That's what Krefler says. There's no such thing as a declarator in a vacuum. It does not exist.
No, that's fine.
In Fose, it says exactly that. That's why we have something called the Gijima principle, because it's against that notion that a declarator in the air might be possible in terms of Section 19 of the Superior Courts Act. It might even be possible under Section 38 of the Constitution, but never under Section 172.1a.
Okay, so we are going to be sending this back to the High Court so they can set aside those decisions.
Yes.
Decisions that were taken when? In 2000?
Doesn't mean, let's say 100 years ago.
Okay.
But the point, Gijima says exactly that. Even if the decisions were taken 1,000 years ago.
No, that's fine. I think I followed the submission.
Yes, yeah.
Okay.
That's the point. You know, that really is the point.
So once the High Court, say they agree with you and they start the
Right.
then what? What is the effect of the order that you can make by the High Court?
Okay. Firstly, that's just the wrong question, because you don't, when you are vindicating rights of human beings, there's no then what. So if you chop my hand and I say, okay, well, I'll never get it back, then what? It doesn't work like that. The mere vindication of the rights is the then what. Okay? So that's what Fose and all those cases leading up to Gijima says. That is a standalone general. That's why it says the court must. The court. If it said the court may, we would be having this debate, because the court would be saying, well, but we can't have this debate because you don't have a choice in the matter. The constitutional drafters decided.
I think you've made that submission.
Yes.
I think
You follow.
I think we followed the submission.
Thank you. Yes.
Sorry. I mean, is there anything else you want to say in relation to any
Yes.
further submissions that you want to make?
Yes. No. I just want
Anything
to,
new?
No, well, this is what I want to do, Justice Panan. I am, thanks to the court and the interaction, I've actually covered the appeal grounds in all its three incarnations.
I think you have, yeah.
Yes. And I just want, if you just allow me just to knit the case together. And the way to knit the case together is to read only one decision, ASLA. Now, it answers some of the interactions that we've had. It says at paragraph 63, ASLA. I mean, this might sound a bit, but that's what the law says. The fourth principle, I think this was Justice Theron, stems directly from Gijima. And I'm going to read this part slowly. This is about the 1,000 years thing. It says, even where there is no basis for a court to overlook an unreasonable delay or mootness or ripeness or 1,000 years delay, even when there's no basis whatsoever, the party just comes here and says, I don't know why I delayed. The court may nevertheless be constitutionally compelled, right, to declare the state's conduct unlawful. So that's the 172(1)(a). This is so because, quote, Section 172(1)(a) of the Constitution enjoins a court to declare invalid any law or conduct that it finds to be inconsistent with the Constitution. Full stop. So that's the law which Justice Theron and even the dissenting judgment of Cameron J.A. and
Froneman.
Yes, even that dissenting judgment did not upset the Gijima principle. And then I'm jumping to 66. She says, when would Gijima apply? Gijima dictates that where the unlawfulness of the impugned decision is clear and not disputed, I've made the Janchi Dube, then this court must declare it as unlawful. So that answers part of Justice Motle's question. This is notwithstanding an unreasonable delay in bringing the application for review, for which there is no basis for overlooking. Whether an impugned decision is so clearly and indisputably unlawful will depend on the circumstances of each case. We've gone through that. I'm not going to traverse that again. And so on and so on. There are many other. You can go to paragraph 68, 71, and so on. I'm not going to read them to try and save time. But please allow me. So the principle is crystal clear. But just allow me, please, to not to flog a dead horse, so to speak, to just say one or two words about the Dube case, just to emphasize the point. Assuming my learned friends are going to argue, which I would be surprised. Well, I wouldn't be surprised because that's what they do in their heads. What Dube says, I was just saying, Justice Mogoeng, when he was still the judge president in the Northwest, sat in a matter, S versus Dube, where his wife was the prosecutor, the state advocate, right? Now, what happened is that Justice, the facts are quite strange, by the way. So the advocate knew that, he said he knew that Justice Mogoeng had set in another appeal and actually found against his wife. So he says he didn't mind. But the appellant looks at the judgment and says to the lawyer, why is the surname of the judge the same as the state advocate? And the advocate says, because they're married. But it's not a problem because I trust him, whatever he said. And the accused said, no, forget that. I'm having none of it. The decision must be set aside. And it was taken to this court. Chancellor J.A. in this court dealt with the matter. It's reported as 2009-2 SACR 99 SCA. You also find it in 2009-3 All South Africa at 223. To his eternal credit, Justice Mogoeng said the following in the special entry. He said, impartiality is the fundamental quality required of a judge and the core attribute to the judiciary. It must exist both as a matter of fact and as a matter of reasonable perception. If partiality is reasonably perceived, that perception is likely to leave sense of unease, grievance, or injustice having been done, thereby destroying the confidence in the judicial system. The perception of impartiality is measured by the standard of a reasonable observer. The perception that a judge is not impartial may arise in a number of ways. For instance, by a perceived conflict of interest, by the judge's behavior on the bench, or the judge's out-of-court association. A judge must therefore avoid all activity that suggests that the judge may be. I'm reading from the paragraph 10, which comes from the Bangalore Principles. Sorry, the passage I was looking for is paragraph 17, where Mogoeng says, we do so because we believe that perception by a lay person that a husband and wife may, in the secrecy of their bedroom, inadvertently or deliberately find themselves talking about the case in which they are involved cannot be said to be frivolous or ridiculous, which is the case. An application for the recusal of a presiding officer in the position of the presiding judge, he was talking about himself, in this matter cannot be said to be absurd or an abuse of process, and an average right-thinking person would, in all likelihood, sympathize with the person in the position of the applicants in this matter. Needless to say, I've already read the other part from the Bangalore Principle. Needless to say, this court found that the grounds for the recusal of Justice Mogoeng in that case were sustained. And the order that was given just was that in the result, the appeal succeeded. Justice Motley, the order of the court is set aside and replaced with the following. It says, the appeal is remitted to the High Court for rehearing before a differently constituted full bench. Now, read what that order is pregnant with, which answers this. What it was saying was that because justice, here you wouldn't say it may or may not be a differently constituted bench. Because in this case, we're not complaining about any bias on the part of the three judges who sat in the Western Cape High Court. If we were, then we would be asking for an order like this. So it would be a matter that's left to the JP to decide if it's remitted. So I just wanted to please bring a 2 or 3 page judgment, but if you take these two cases, Janji, deal with the committee and the chairperson, Dube, deal with the Mileham recusal. In those circumstances, I don't know if I should preempt the so-called cross appeal. Let me do that in one sentence.
No, you can deal with it.
Yes, just for the sake of completion. Yes.
You can deal with it when you're on your feet later.
Yeah.
Perhaps you may benefit from the debate that will be had with counsel for the other side.
Okay, I will not, because there's no they want personal cause against a person. So she's a person now. So the cause will be personal anyway. So, but anyway, I will maybe benefit from whatever they have to say. Sorry, this man. Those are our submissions.
Yes,
the appeal should succeed, and the order along the lines we've discussed ought to be granted, as the court pleases. Sure, thanks.
Justice Pond. I'm going to attempt to confine myself, unless the court wishes me to do otherwise, to the two preliminary points that are contained in your directions.
Thank you. I would, speaking for myself, I would appreciate that.
If I need to go beyond that, I will indicate where and why, Justices. And so it's my firm intention not to deal with what I call the merits.
Yes.
If we are called upon, as part of our address, to deal with the merits, my learned friend to my left, Mr. Naidu, will deal with in medias res and with the grounds of review to the extent the court wishes to hear that.
Yes, thank you.
So with that said, I'm going to deal with the two preliminary points. Now, my first submission, Justices, with regard to Rule 15, is that as a general proposition, it would find no application in this court. It is not designed with respect, and it doesn't state that it is applicable in proceedings before this court. So that's my first proposition. The second proposition is that in at least two cases that we've come across, and we looked at that obviously once we got your notes, so it's not in our heads of argument, Justices, but there are two cases which do deal with this question, and where this court has in fact invoked Rule 15 of the High Court rules. The first case is Ardendorf's Boerdery versus Shabalala, and the neutral citation is 2017 ZASCA 37. The judgment of this court on 29 March 2017. And in that case, Justices, if I could just read from para 18, there was the respondents in that matter applied for postponement of the appeal, and one of the grounds was that the second respondent had passed away and an executor had not been appointed in his stead to proceed with the matter. And this is quoting from para 18 of the judgment. Counsel for the respondent argued that time was needed to adjust the papers and to substitute the prospective executor. During argument, it became clear to counsel that the non-substitution of the executor could still be done at a later stage. And then there's a reference to Rule 15, Justices. So there the court appears to accept that Rule 15 can be invoked at this stage. But I must point out, and can I just preface these remarks by saying, it would make my job easier, our job easier, and it would be convenient for us to say, yes, of course, they can invoke Rule 15 and have them before the court because we want costs against them. I can't do that properly because I must obviously bring these authorities to your attention, so I bring them to your attention. That, and our position is Rule 15 cannot be invoked at this point. And quite apart from that, they haven't properly invoked it. But I'll elaborate on that. So I'm just dealing with the jurisprudential basis. So this case says yes, but it provides no reasoning for that conclusion. So that's the one case. The second case, Justices, that we came across is in Gwenia.
Can I just ask, who was that judgment written by?
Who was the judgment written by, Justice? It was written by the bench. It was written by Matoko, J.A., and the bench was Shongwe, Majid, Van der Merwe, and Mbata A.J. And then the second judgment, Justices, is Gwenia N.O. v. Kruger, and the neutral citation is 2017 ZASCA 102. It's the same year, judgment handed down on 6 September 2017. Similar, there was an overlap on the bench. It was Shongwe AP, Bosiello and Majid, JJAs, and then Moho, Loa and Furi, JJAs. And in that matter, Justices, Gwenia versus Kruger. And in that case, Justices, the judgment in para 1 says that counsel were at the outset required to address whether the appeal in any order mode would within the meaning of section 16.2a1 of the Superior Courts Act, have any practical effect or result. And after hearing argument on the issue, the appeal was dismissed for costs. And it would indicate the reasons would follow. These are the reasons. That's para 1. And then in para 4 it says the following. On 27 January 2017, before the hearing of the appeal, the first respondent passed away. This resulted in the parties being requested on 21 June 2017 to file supplementary heads of argument on the preliminary question referred to in paragraph 1 above. In other words, the question that I've just read to you about section 16. The parties duly filed supplementary heads of argument, and I should add that at the commencement of the hearing of the appeal in this court, Justices, an application was granted pursuant to Uniform Rule 1512, in terms of which, basically, the respondent who died was substituted for the first respondent in this appeal. And then the court goes on to deal. So again, no reasoning and no jurisprudential basis laid. So those two judgments are against us on the issue, but we say they have no reasoning with great respect to them. Then there is the judgment that you handed to us this morning, Justice Ponin. And as we read the Cilliers judgment in para 25, which you brought to our attention, there the court too appears to accept, but on my reading of this judgment, again without any reasoning as to how it arrives at that conclusion, that Rule 15 can be invoked at this point, and then takes the point of the fact that it had not been invoked, and raises the question of the proviso, which you've made, or which you've raised, and says that leave of the court was not sought. My learned friend responds to that by saying, well, you can do that at any time before the hearing, but the logical, or we submit, the jump of illogic that he makes is to read the rule as if it's applying to the SCA. It obviously applies, Justice, to the court, a quo, the High Court. You cannot once, and that's what the rule says on its face, it doesn't speak of the SCA, it doesn't speak of an appeal. So we submit that his answer doesn't address the issue of whether you can invoke the rule at all in this court. We say you can't.
I think in part that's probably the reason why, for example, Harms and Erasmus expressed doubt as to whether or not Rule 15 can apply post-judgment, and that's post-judgment in the court below.
Yes. Now, all of those, Justices, are interesting questions, but as we all know, my learned friend is quite correct about this. Rule 15 was inserted in the rules to provide an easy mechanism, because before that, as you quite correctly pointed out, we at least ad idem on that. I think it's possibly the only aspect this morning or today we are going to be ad idem on. We had idem, Justices, that before Rule 15 you required a substantive application to substitute a party. Rule 15 provided a shortcut, but it provided a shortcut under very specific circumstances, and the circumstances were a change in status. Now that is the elementary point, because with respect, if, as you put, my learned friend, if they brought a substantive application, Justice, in this court, or before, and in fact, as we will argue, it should have been brought before, because the facts are, there's a timeline that's very important to appreciate, and it goes back to the High Court, but also in this court, or what happened in this court, how the appeal was brought here. And we submit, to once again give you a shortcut to where we're going, we have, in terms, pleaded in our answering affidavit, and there was no reply to it. They never disputed this. We've pleaded in our answering affidavit, para 38, that upon the suspension of Advocate Ngubane, and I'm going to say Advocate Ngubane to distinguish her from the public protector, upon his suspension on 9 June 2022 by the President, she lost, by operation of law, Justices, Section 2, capital A, sub 7, divested of all the powers of public protector and those passed to a deputy in terms of that section. So that's an important date, because 9 June 2022 is when she ceased to have the power to act qua PP, public protector. And she never regained that power, because although that decision was overturned by a full bench of the High Court in Cape Town in August of 2022. There was an appeal by both Parliament and the DA, and that suspended that order. There was a Section 18 application by Advocate Mkhwebane, which failed before the High Court. And those matters all went directly to the Constitutional Court. And that ended up as DA versus Public Protector, the judgment that we've cited. And I'll get to the relevance of that in the order, but the fact of the matter is, what's important to note, Justices, in the factual timeline, is that from 9 June 2022, Advocate Mkhwebane could no longer act qua PP. But yet, she instituted proceedings in the High Court under that guise as PP. And she noted the appeal to this court as PP when she no longer was such. To come back to the Rule 15 notice, the Rule 15 notice, Justices, as you, Justice Ponden, have pointed out, was elicited by the Rule 5 notice by the DA in this matter. And in that notice, she was called upon to demonstrate by power of attorney that this appeal was properly before this court. And the response is the Rule 50 notice that attempts to supplant her for public protector in her own name and in her own name. And she accepts, you've heard that this morning, that she does not litigate as the public protector. Now, given that factual scenario, we submit that had she wanted to effectively bring herself before this court as herself, Advocate Mkhwebane, she should have brought an application. That would have had the effect that we could have responded to it, and that the question of any prejudice, the question of the legal implications of the previous litigation, the attempt to come to this court would have been dealt with factually, and the court could have made a ruling in that regard. That is not what you have at the moment. You simply have a notice. And the notice, with respect, doesn't achieve the object of putting her before this court as in a personal capacity. Because, for the reasons I've given, well, those are the more technical reasons. To get to the substantive reason as to why the notice is not effective, Justices, there has not been a change in status such as contemplated in 15.1. The change of status, examples are given, we accept they're not exhaustive, but a change of status involves precisely that. And here there's not been a change of status in the office of the Public Protector. The Public Protector remains the Public Protector. The difference that occurred back in June is that she was divested of her powers to act as such, and then what happened subsequently, as you know, Justices, we've dealt with it in our heads. It's also been found in the DA's Rule 5 notice, is she was firstly impeached by the National Assembly. That occurred in September 2023, and then she was removed by the President in that same month. Those are the changes that occurred. But that is not a change in status, or not a change in status in relation to the Public Protector. And the Public Protector is the party before you in this appeal. And we fully accept that this court has inherent jurisdiction to regulate its own process. This court could, we would submit, if you wanted to be conceptually clear, even suo motu, we would suggest, admit Advocate Mkhwebane as a party in this appeal. But that is not the application you have before you.
Well, even
There's
that
no
may be,
such suggestion.
Even that may be technically a little difficult because, unlike the High Court, for example, our position is somewhat different. A necessary jurisdictional prerequisite is the grant of leave to this court. Now, if leave is granted to one party, and then you have another party standing up with a view to prosecuting that appeal, and that party is not properly before you, well then there isn't a proper prosecution of the appeal. And we can't, by dint of regulating our own procedure, appropriate to ourselves a jurisdiction we don't have. It's only if we have jurisdiction that we can regulate our own procedure. So there's a preliminary step, in a sense, that's missing technically. If you follow what I'm putting to you.
Absolutely. What I'm saying is,
unless the substitution in some or other guise succeeds, we don't have an appellant before us.
That is so. Because, with respect, that is abundantly clear from the Rule 5 notice. And Annexure B there too, which you have before you, we've been told. We inquired whether these documents had been placed before the court, and we were told it had. So you have a Rule 5 notice, albeit from the Democratic Alliance. It had two documents attached, one a letter from the attorney and then the response from the public protector. And that response is very clear. The public protector says, we did not authorize these attorneys to prosecute this appeal, to note an appeal or prosecute.
Yeah, well, leave was granted in my name, but I have no intention of prosecuting the appeal.
I'm sorry, Justice.
I'll say, essentially, the current incumbent of that office seems to say, leave was granted in my name, but I have no intention of prosecuting that appeal.
Not only have I no intention of prosecuting the appeal, I never authorized the noting of the appeal.
Exactly.
So, under those circumstances, Justices, with respect, the appropriate order that we say should follow, and those are the facts, which is why I wanted to make it clear what the facts are. The facts are suspension in June 2022, impeachment and removal by the President in September 2023. And notwithstanding those facts, supposedly the public protector continues to proceed with this case. But we now know, unequivocally, Justices, that the Office of the Public Protector never ever authorized that. And the question that you then ask, and as you quite correctly point out, that's the principal, very first question, before you go to any other legal debate, is there a matter properly before you? And we say that the crisp answer to that is no. There is no proper appeal before you, because it has not been authorized. And the relevant or the correct approach we submit under those circumstances is what occurred, Justices.
Well, there may not even be an attorney properly before us.
I'm sorry?
I say there may not even be an attorney properly before us. Because
there is no attorney in relation to the appeal, no.
Because the question that was raised is, are you duly authorized to prosecute this appeal on behalf of the person who got leave?
That's
and
correct.
The response was the Rule 15 application. So that
is an unequivocal.
The earlier notice, that wasn't regularized in any way either.
No, it's the appeal notice has never been, there's been no attempt to regularize that. The response to the Rule 5 notice, which expressly asked for a rule for a power of attorney, as the rules provide for, the rules of this court provide at any point the authority of the party can be requested to be established. That was expressly invoked, and the response to that was expressly not to provide such a power of attorney, which would then demonstrate that the leave to appeal, or rather the notice of appeal, had been properly lodged and the appeal properly prosecuted. The response, in fact, unequivocally was to accept that that could not be done, that proof could not be provided, hence the reliance upon, or the fallback onto Rule 15, which doesn't achieve any of the objects sought to be addressed in the Rule 5 notice. Under those circumstances, the only legal but also factual conclusion the court can reach with respect is that there is no appeal before you. And that should be, well, must be the end of the matter. This court, as you quite correctly point out, Justice, has no jurisdiction to entertain a matter that's not before us. Notionally, the court could substitute a party, but that would be under, and the submission earlier mustn't be misunderstood to say the court will entertain a party before it who isn't before it at all. The court may resolve
and issues sua motu within its inherent jurisdiction in relation to an appeal that it is seized with, non-constat that it will deal with matter which it's not seized with. And we submit it's not seized with this appeal. Now, under those circumstances, the question is what does the court do under those circumstances? We submit with respect, Justices, and the principle is, and we say this judgment, the judgment of this court is analogous on the facts. It's the case of Land and Agricultural Bank of South Africa. Can I just check one thing, Justice? Land and Agricultural Bank of South Africa v. Parker and others, 2005, Volume 2, page 77, SCA. That was a judgment, Justices of Mpati DP, with Cameron, Brunt, JA, and Erasmus and Jafta AJA as the bench. And in that case, there had been a judgment of the Court of a single judge, which had then gone before a full bench down below. And the full bench overturned. The judgment of the Court of First, or the single judge, was a sequestration order. The court, the full bench, I quote, overturned that, and then it came on appeal to this court. And it became common cause, Justices, in the course of the matter, that the trust, who was the respondent in the Supreme Court of Appeal, had not been properly constituted at the institution and at the time that the matter came before the full bench in the appeal, because one of the trustees, the trust deed required 3 and there were only 2. There had been 3 initially, but during the appeal stage there were only 2. That was remedied by the time it came to this court. And under those circumstances, the court deals with the matter at para 45 and 46. And well, let me just read it to you very briefly. Before us, counsel for the trust sought to suggest that the original resolution of the three trustees adopted to resist the sequestration application covered subsequent steps, but this is manifestly not so. The resolution was only to oppose the application for sequestration in the High Court of South Africa. This neither contemplates nor authorizes an appeal, nor was the full court appeal at any stage ratified on behalf of the trust. Whether by design or oversight, no such ratification was attempted after the third trustee was eventually appointed. And then, 46, it follows that the full court should have concluded that the trust was not before it and struck the appeal from its well on that ground. The appeal must therefore succeed and the judgment of Ruja reinstated, and then it makes an order, Justice, in this court, upholding the appeal with costs, and the substitution order is the appeal is struck from roll with costs, and then, importantly for our cross appeal, or not for our cross appeal, importantly for our argument before this court as to what should happen to the costs in this court, is para B of that order. The trustees, individually, the two, who brought the appeal proceedings without authority are to pay the costs from their own pockets, jointly and severally. Now we submit that is the appropriate order for today, Justices. The appeal should be struck from the roll or dismissed. In the Cilliers matter, the appeal was actually dismissed. So the court should dismiss or strike the appeal from the roll with costs. Given that there's a clear lack of authority, well, the PP is not here at all, hence it must be struck. The person who acted qua PP, who represented that she could prosecute this appeal for the PP, as in Parker, should bear the costs. And we would ask for such an order in respect of the so-called appeal, the proceedings before you. Those are our submissions on Rule 15, Justices, and what should happen to the matter today. I don't know whether the court wishes to hear me on mootness.
Well, even on the approach that you just postulated, might I suggest that mootness may still not be entirely irrelevant. And it would perhaps be relevant in a slightly more nuanced way. And that's the following. I mean, assuming one gets past all of the difficulties that you just alluded to, that's from the perspective of the party who now purports to prosecute the appeal. There's a line of authority, as with, for example, amendments and so forth, to pleadings. There's a line of authority that appears to suggest where, for example, there is nothing meaningful to be achieved in ordering a substitution, then substitution shouldn't be granted. So, for example, even if there had been a proper formal application, not a notice in terms of Rule 15.
Sorry, you're talking about substitution of a party, not substitution as a remedy.
No, I'm talking about substitution of the appellant.
Of a party.
Yeah.
Yes. Yes.
So, what I'm suggesting is the following. I mean, in a situation where, for example, there is, had there been a proper application, in other words, had Rule 15 not been invoked, and had there been a proper application, and this court was required to consider that application,
Yes.
that's the exercise of a discretionary power by and large.
Yes.
But in the exercise of its discretion, this court may well have said, well, even if one overcomes all of these obstacles in the path of the appellant, there's still the question of mootness. So that in and of itself, at the tail end of the inquiry, will also render a substitution meaningless in the circumstances. I mean, I think that's what I'm putting to you.
Oh, I
so,
see.
yeah.
So do you want me to briefly address?
No, I'm just raising it at that level. I know we've got your submissions on your heads of argument. I don't think it's necessary for you to, unless there's anything you want to touch on.
We would submit, Justice Ponnen, that clearly the court would be able to take into account the fact that if it had reached a firm view on mootness, that it would factor that into its consideration in the exercise of a discretion, which we submit would be a wide discretion.
Yes.
It could consider that and would consider that, absolutely.
Yeah, I mean, what I'm suggesting to you is you'd find a line of authority, for
Yes.
example, where prescription looms large.
Yes.
And the court would say, well, there's little point in ordering a substitution because one way or the other, prescription would probably operate even as against the new party who's coming into the thing. And
Yes.
I'm saying, analogously,
In the same way an amendment.
yeah, analogously, if the matter is moot,
Yes.
then similar considerations should obtain.
Absolutely, absolutely. There is one aspect on mootness that we do want to emphasize, on mootness that we do want to emphasize, Justices, and that is my learned friend attempts in his address to you to draw a bright line between the 172.1a relief, he says, and the review relief, and possibly the 172.1b relief. With respect, as we read the notice of motion, that's not how this application was ever conceptualized and conceived. And just very briefly, the starting point is, even at the point where they noted the appeal, when they got leave to appeal, it's in the core bundle, Justices, at page... Their notice of appeal is to be found in the core bundle at pages 49 to 51. And this is the relief at page 50 that they sought to prosecute in this appeal. And you'll find in that, let me read it to you, it's para 2. This is the order that they want, that they came to court, that we've come to this court to oppose. It's 1, the appeal is upheld. 2, the order of the court a quo, which is the dismissal, is substituted with the following order. The application is granted, in other words, this is what the High Court should be doing. The application is granted as prayed with costs, including costs. The application is granted as prayed. No distinction, not alive, Justices, to the distinction between para 2, characterized as a different type of relief. They wanted all the relief was prayed. And if you don't have to strain yourself and do any injustice to the appellant / applicant, to Advocate Nkorbani, by just looking at her notice of motion. Because on a plain reading of the notice of motion, Justices, the declaratory was always the the springboard for the other relief. It's not pleaded. And I spent some time looking at the founding affidavit. And whatever the argument may have been in the court below, this is not the way the matter was pleaded. So if you look at the notice of motion, the declaratory in 2, declaring that these things were unconstitutional and invalid, flows naturally into 3, setting aside the said decisions referred to in 2 above, and then 4, substituting the said decisions. There's no distinction in 2 between 2 different types of 2, 2 as a standalone declarator in terms of 172.1a, and 2 as a precursor to the consequential relief. You don't find that there. But what you do find is then 4, which again clearly is an order meant to be executory pursuant to 2 and 3. This is what they want. And that's perhaps, and then the main, and you get that in 4.4, which is the next submission. This entire exercise was not, whatever you may have heard this morning or today, this was certainly never conceptualized and never moved. And you can also look at the urgency with which this was brought. If you look at the first page of the notice of motion, it was launched in November, instituted on 8 November to be heard 13, 14 December. So the whole thing was intended, and it says as much in the founding affidavit. It was, and you can see that most clearly from 4.4, because what they wanted, justices in the High Court, was an order in 4.4 that the committee proceedings will only take place after its composition has been duly corrected and confirmed by this court. So the whole idea, this entire application was brought about, not to stop because they sought no interdict, but to get an effective order apropos those proceedings. That is how this was conceptualized. And the founding affidavit, with respect, makes that clear. Yes. Yes. So that was what this was about, whatever legal arguments you may have heard. For the rest, justices, we've dealt with the authorities, and just from the legal point of view, I just want to emphasize what we've said apropos Glenister 1. You find it at para 59 of our heads. And Glenister 1 puts paid, we submit with respect to this notion that mootness and a matter not being ripe, which my learned friend says are flip sides, don't have application when one is seeking a 172.1a order. It does. And that's what Glenister says. Makes it very clear. And there's no conceptual basis as to why it shouldn't, with respect. So those are submissions. I'm not going to take the court into mootness further.
Yes, thank you.
With regard to the cross appeal, just briefly, Justices, we've made our submissions in that regard.
Why do you have the right of appeal? That order doesn't operate against your client.
I'm sorry?
I say, why would your client have a right of appeal? The order doesn't operate against your
A
client.
right of cross appeal.
Yes.
The order doesn't operate against my client.
As against your client.
As in my client being the chairperson of the Section 194 committee.
Yeah. I'm saying that relates to costs. That's an order that doesn't operate as against your client.
The order doesn't operate against our client.
I know you sort of acting in the public good and that kind of stuff, but so what? Why would that give you a right of appeal?
Justice, it's more discreet and focused than acting in the public good, acting for the public good. We as part,
No, well, you would have a right of appeal as against an order that operates against you.
There's no doubt.
In this instance,
well,
I know what the thinking was. You were seeking to ensure that the public purse is protected, and that in fact the individual who was litigating for her personal benefit, that she would be held liable for costs. But ultimately, you came away from the matter with your costs, and in those circumstances, it's not like, insofar as a cost order was concerned, you were out of pocket. You got costs. You may have got it from not quite from the party that you wanted it from, but you got your costs. And so, to the extent that there may be any outstanding issues, that would be between the present public protector and one would imagine her predecessor.
Just as the Constitution obviously requires Parliament. The public protector is accountable to Parliament.
Yes.
And it's in the exercise of that overarching power to oversee the activities of the public protector that we came to court on the cross appeal. So it's not some general desire to look after the public purse. It's located squarely within the provisions of the Constitution. It's section as it is section just as...
Well, can we then start with your answering affidavit?
Yes.
Let's just look at the two that I have in mind. I mean, the one is at 1518, and I mean, I think this may not quite be your client, but...
15?
This relates to the DA, and that is that they asked for the application to be dismissed with costs, and that's at 1518 and at 1569. So...
Of the record?
Yeah.
Oh,
and
sorry.
so, insofar as a cross appeal in their hands is concerned, I suppose they are probably in somewhat of a worse position than your client is. But the point still remains. I mean, ordinarily one would appeal against orders of court that operate against one.
Justice, this is not an afterthought. We always, so in our answering affidavit at para 343, page 775.
Sorry, just let me find that.
And this is not a surprise. It shouldn't be a surprise to Advocate Mbokwane. I can also just point out that she sought a personal cost order against the chairperson.
Yeah, no, that may be so.
And in response, but I'll point that out. But 343, we say that should the application fail at 775, costs should follow the result. In such event, however, the long-suffering taxpayer will again have to pay Advocate Mbokwane's legal costs, given the circumstances in which this application has been brought, and the unmeritorious grounds. The court may well wish to order that she pay those costs personally. And then we ask expressly for such an order at para 424.2 at page 797. So she was put on notice.
No, that may be so, but I'm dealing with a slightly different point, and that is, at the end of the day, the application is dismissed. It's dismissed with costs.
With costs.
And so, it's not like any portion of that order operates as against your client, which would lend itself to an appeal at the instance of your client.
Justice, I can only say that Justice Bonnen, we asked for leave, we got leave, but I'm not going to press it. You have our submissions.
Yeah.
The cost in this...
well, that's a different kettle of fish in Thai.
They differ, Toto Keller. I've made my submissions in that regard.
Yes, certainly.
And could I just point out, just my final point, is that in DA versus the public protector, the court made precisely such an order where it found in the Constitutional Court made precisely such an order. You have the case, it's referred to in our heads of argument, Justice, but I don't think this paragraph. 161, as to this cost of the Section 18 application for leave to appeal, the DA and the President saw costs against her personally. It is highly regrettable that this court and the other parties were burdened with an entirely unnecessary application. There is no indication that it was authorised by the Office of the Public Protector. In that case, there is no basis to hold the Office of the Public Protector liable for the costs. She must therefore pay the cost of the application in a personal capacity. So that's the basis.
Yeah, I understand the thinking, but I just have a bit of a conceptual difficulty with why an appeal would avail a party. Yeah.
Sorry. This is not made.
Okay.
Sorry, that was not in support of the High Court costs.
Okay.
In support of the costs in this court.
Yeah.
Today's costs.
Okay. I mean, the one thing that struck me about this is, for example, the question of standing arose squarely before the judgment on the application for leave. And I know that judges on the High Court are under immense pressure and the workload is unbelievable. But that is almost just glossed over. It's passed over because that may well have impacted on whether or not, on mootness, on standing, on right to prosecute an appeal, and whether or not leave should have been granted.
Absolutely. I just want to check. Could I just check on? I just wanted to confirm that was certainly argued by us justice.
Yes.
Down below. That those were grounds not to grant leave to.
Yeah. Thank you.
As a completeness. You do not then want to hear us on anything else.
Thank you.
As a completeness.
Be brief, especially with the application of Rule 15, before touching briefly on just two principles on the issue of mootness.
Yes.
The uniform rules, in relation to the Rule 15 question posed by the court, the uniform rules of court apply to the conduct of proceedings in the divisions of the High Court. The granting of the leave to appeal by the High Court and the noting of an appeal in this court, I submit, engage the appeal procedure which is regulated by this court's rules. There is no equivalent to Rule 15 in this court, which is a procedural mechanism. It doesn't establish a right, a power to substitute. This court would rely on its inherent jurisdiction for the substitution power. But as pointed out, this court has nevertheless utilized the mechanism of the Rule 15 in a few cases. Before turning to those examples and why I think they're distinguishable, I just want to reiterate 2 points in relation to the application of Rule 15. The first is the ability to utilize the mechanism requires it to be a situation as contemplated in the rule. And that's been confirmed by this court in TechMed, where it says the effectiveness for Rule 15 notice will obviously depend on whether it was given in a situation covered by Rule 15.1. The second point is there's also proviso to the application of the rule, which is set out in Rule 15.2, that no such notice will be given after the commencement of the hearing of an opposed matter unless leave of the court is given. Now, I want to turn to the instances where this court has utilized Rule 15 and explain why we submit that it's distinguishable. In McGuenia versus Kruger, the citation that's already been given to the court, at paragraph 4, it states that the court was dealing there with an application that was granted pursuant to Rule 15.2. In Morer and another versus Maposa, which was referred to on behalf of Advocate Makubane, at paragraph 6, that was dealing with a situation where the executor brought an application in terms of Rule 15 for substitution. Paragraphs 10 and 11 of the judgment refers to that application being opposed. And TechMed again says at paragraph 13, where substantive application for substitution has in fact been brought, any investigation into the effectiveness of a preceding Rule 15 notice is most likely going to be a futile exercise because we now have a substantive application before the court. So given that there was an opposed application in that instance, the court need not have considered whether Rule 15 notice was the correct procedure to be invoked in the appeal court. In Ardendorf versus Shabalala, also referred to earlier, at paragraph 18, the court was dealing with the hearing of an appeal where the respondents launched a two-pronged application for postponement of the matter. One of the reasons being that the second respondent had passed away and an executor had not been appointed in his stead to proceed with the matter. During argument, it became clear that counsel thought that it became clear to counsel that the non-substitution of the executor could still be done at a later stage. But that was distinguishable, again, from the present instance, because there we were dealing with the circumstances where Rule 15.3 applies, which deals specifically with the substitution of an executor, where it says...
But at their instance, whether it be an executor or a trustee or a curator,
Correct.
so they seek to become parties, and it's at their instance,
Indeed.
not at the instance of someone else who may be already before court.
Indeed, Justice Coonan. And so the proviso in 15.2 that says you can't have it apply without leave in opposed hearings, that's not applicable to 15.3. 15.2 refers specifically to where notice is given for a circumstance that's triggered by the 15.1 change of status issues. And the last case we have is the Cilliers case that was provided us this morning, which again says where we have an opposed hearing, leave of the court is required. So for all those reasons, I submit the Rule 15 procedure in terms of just delivering a notice indicating there's been a change of status was not open to Advocate Mokbane in this court. But even if this court is not with us on this submission and says the mechanism for Rule 15 applies, she has not met the requirements set out in Rule 15.1, which is death, marriage, or change of status. And to this extent, I endorse the submissions advanced by Learned Senior Counsel for the chairperson on the issue of change of status.
Sorry.
I would just like to reiterate, Advocate Mokbane is not litigating in the capacity of Section 181 in terms of the Constitution. That was made clear in the address earlier. That refers to the juristic person.
I'm sorry.
No problem. That refers to the juristic person established in terms of Section 5 of the Public Protector Act. She certainly doesn't describe herself in that manner. As Justice Masipa pointed out, Advocate Mokbane describes herself in the High Court application simply as, at page 10 of Volume 1, Paragraph 3, I am the applicant. There's no reference to her being triggering the capacity of the Office of the Public Protector. Similarly, the reference in paragraph 1 of her founding affidavit of being duly appointed in terms of Section 1A2 does not suggest that she's here in the capacity of the Section 9 institution. The nature of the relief claimed by Advocate Mokbane makes it clear that the relief sought is in her personal interest. It's specifically tailored to her circumstances, undergoing an inquiry into her fitness of office, and not in the interests of the Office of the Public Protector. It relates to securing witnesses to testify and the delay of those proceedings. So we're simply not dealing with a change of status here as contemplated by Rule 15.1. So for those reasons, it was not open, if this court were to find that Rule 15.1 can be utilized as a mechanism despite it not being catered for in the SCA rules, it was not open for her to utilize the notice requirements simply because there hasn't been a requisite change of status. Rather, she needed to engage this court's common law power by bringing a substantive application to allow for substitution, or amendment of the citation, or introduction of herself as a new party to these proceedings. In the substantive application, Justice Poonen, you put the question to counsel for the chairperson as to whether mootness would come into consideration. And the court's been clear that when a substantive application for substitutions before it, it would apply similar considerations as to when considering an application for an amendment. And that would include the question of prejudice. And it would also consider whether there would be any injustice to the other side. And we submit patently where the relief sought in the appeal would have no practical effect. It's patently prejudicial to go through an academic exercise of dragging the other side through to an appeal through the substitution. Justices, those are my submissions on the application of Rule 15. Unless you have any questions, I'd like to move on to make brief submissions on the issue of mootness. Justice, we've dealt with the address mootness comprehensively in our heads, and I don't intend to repeat that. I just want to make 2 points in relation to the address we heard this morning. In order to avoid the obvious fact that this appeal will have no practical effect, what we've heard is that the Gajima principle must apply, and there ought to be a remittal for the declaratory relief. In relation to the application of Gajima, I submit it does not apply in the present instance. The Constitutional Court in Buffalo City said, when considering when the Gajima rule would apply, said, it dictates that where the unlawfulness of the impugned decision is clear and not disputed, then the court must declare it unlawful. This is notwithstanding an unreasonable delay in bringing the application for review, for which there is no basis for overlooking. In the present instance, the unlawfulness, if there was any, is neither clear nor is it undisputed. And the Gajima principle applies only to an unreasonable delay and not to other legitimate reasons for refusing to decide the merits. In response to the submission that the declaratory relief ought to have been dealt with, we have also dealt with the application of 172(1)(a) in our heads of argument. But I'd like to just reiterate 3 points, if I may. The first is the argument on behalf of Advocate Mkhwane misconstrues the rule of Section 172(1)(a). That section does not determine when a court is required to consider the merits of an argument before it. If this was the case, then it would render the rules on standing, ripeness, and moot nugatory, despite there being legitimate reasons why a court can refuse to entertain the merits of a challenge to law or conduct. The Constitutional Court, in the matter of JT Publishing, Pty Ltd and another versus Minister of Safety and Security, the citation is 1997, Volume 3, SA 514. The court said this: the reversal of the decision reached in the court below brings duly before us a claim for a declaratory order which the applicants wished us to grant on the constitutional issues presented by them. That does not necessarily mean, however, that we are now bound to resolve those issues. Whether we should say anything at all about them must be settled first. Whether we should say anything, I interpose the inquiry because a declaratory order is a discretionary remedy, in the sense that the claim lodged by an interested party for such an order does not itself oblige a court handling the matter to respond to the question which it poses, even when that looks like it's been capable of a ready answer. It goes on to say, it's a well-established and uniformly observed policy which directs them not to exercise it in favor of deciding points that are merely abstract, academic, or hypothetical. And that's precisely the circumstances we find ourselves in the current appeal. And the final point I'd like to make in relation to the declaratory relief is that applying it would then effectively allow for circumvention of the in medias res rule. What it means, it suggests that a court can never declare to grant a declaratory relief, in effect allowing it to grant the same relief a review court would, declaring conduct unlawful. Apart from those submissions, I endorse the submissions from learned senior counsel for the chairperson regarding the conceptualization of the praise in the notice of motion and whether they support the declaratory relief sought in the submissions today. Justices, the final issue is just the cross appeal. I don't know, we've set out our basis for that. There's only one additional point that I'd like to make in relation to that, and that would be the cross appeal is unaffected by the subsequent events. Advocate Mkhwane was the public protector when the High Court decided the application. The order that she pay personal costs would attach to her and not the current public protector. But if the court has concerns to the fact that any substitution would potentially have an interpretation that the current public protector would face a personal cost order, I submit the court's hands are not tied. Section 19D of the Superior Courts Act grants this appeal court wide powers to confirm amend or set aside a decision which is subject of an appeal, and render any decision which the circumstances may require.
Can that order be the subject of an appeal at the instance of your clients?
Justice Pinnan, we requested the personal costs in the heads of argument on the advancement that the public should not be mulcted with those.
Well, I understand the rationale, I understand what the motivation was, but I'm dealing with it at a slightly more technical level, and that is, ordinarily litigants can appeal against orders that operate as against them.
Yes.
Now, this is not an order that operates as against you. I can understand if the current incumbent, the present public protector, were to have sought leave to appeal, and if she were before us saying, this had absolutely nothing to do with the legitimate business of the office of the public protector, and therefore that office shouldn't have been mounted with costs. I can understand an appeal at that level. What I don't understand is why would your client have an appeal against an order that doesn't operate against it? You may be aggrieved by the order, but does it give you a right of appeal?
Just put in, that's been pursued in the public interest. I appreciate the concern, the conceptual concern that you have, and I don't think I can take it any further than that.
No, I appreciate that as well. Yes, thank you.
Unless there's any questions from the court, those are my submissions.
Thank you very much.
Thank you. So, I don't know. Yeah. Well, let me start while it's still fresh with the last submission which was made. A lot of astounding submissions have been made, which one doesn't even know where to start. You can't conflate, as my learned friend who just spoke now, the declarator that is sought in terms of Section 8.1d of PAJA, which is indeed discretionary, with the a declarator that is sought in terms of Section 172.1a, which is compulsory. How the two things can be treated as the same beats me. It would mean that the drafters of the Constitution didn't know what they were doing when they put the word must in Section 172.1a and put the word may in Section 8.1d and even in Section 38 of the Constitution. Section 38 of the Constitution and 8.1d are discretionary remedies, but the remedy in Section 172.1a is not a discretionary remedy. That's why I was saying they're two worlds apart. But that's not the only misconception. So the principle of in medias res obviously applies in the respect of the relief sought in terms of Section 8.1d. It even applies, I'm prepared to concede, to the relief sought in terms of Section 38. But it cannot apply without applying the Gijima principle to the relief sought in terms of Section 172.1a. I don't know which part of that is not clear, that these are three separate causes of action. Now, it's very clear that JT Publishing, we all know JT Publishing, does not take into account the subsequent jurisprudence of the Constitutional Court in Gijima, in Asla, there's another case called Nochawela or something like that. Sorry. I think it's the most recent case on this law. Notyawa. Sorry. Just give you the, sorry. Yes, it's Notyawa versus Makana Municipality. That's probably the citation that says 2024 or 41 or 4I, ILJ 1069, decision of the Constitutional Court. So there's a string of cases from the Constitutional Court that have now applied the Gijima principle. And as I indicated, even the dissenting judgment in ASLA confirmed that principle. So how anyone can use the pre-Gijima jurisprudence to make the point that the relief in 172 is all discretionary, both A and B, is just more than astounding. Now, we are told that something else which is, don't know how to describe this one. My learned friend says that the principle in Gijima only applies to unreasonable delay. That is just false. This is what the court said. It didn't confine it to unreasonable delay, but to all procedural hurdles, as I think that was the word that was used, and procedural obstacles was another word that was used. You'll find that in ASLA at paragraph 67. It says, on the one hand, there is a long line of cases explaining that the state must adhere to the procedural requirements of review. We all know that, whether the ripeness, mootness, in medias res, and so on, not just on delay. And then it says, including timeous approaches to the courts. So it's not confined to timeous approach, including that, right? Then here's the real law. On the other hand, Gijima implies that these procedural hurdles, all of them, not just unreasonable delay, while important, can sometimes yield to the injunction under Section 172(1)A to declare invalid that which is inconsistent with the Constitution. So how can anyone stand here and say that judgment is confined to unreasonable delay? Well, he says it includes unreasonable delay and all other procedural hurdles. And then at paragraph 68, this is not even something that's introduced by Gijima. It was introduced in Khumalo, which was in 2014, I think. So at paragraph 68 of ASLA, it says, in Khumalo, this court cautioned against allowing procedural obstacles, not just unreasonable delay, all procedural obstacles, from preventing, which is what is being asked of you today, from preventing a court from looking into a challenge to the lawfulness of an exercise of public power. Square J stated, quote, a court should be slow to allow procedural obstacles, all of them, to prevent it from looking into a challenge to the lawfulness of an exercise of public power. Can't be clearer than that. But that's paragraph 68. So it's false to say that the Gijima principle only applies to unreasonable delay. It's just patently false. Then we are told that, I have to say this. As I said earlier, the reason why we're here before justices, people called justices, is because this is where justice is to be obtained. And we had, as I say, we did not get justice in the Western Cape Court because of the complete misapplication of the in medias res principle, which only applies to reviews.
Sorry, I don't want to interrupt you, but doesn't
Yes.
Venister 1 make it applicable to declaratory relief as well?
Doesn't?
Doesn't Venister 1 make it applicable?
No. Okay, let me explain. No, Clenistal 1 doesn't at all do that. Clenistal 1 talks about legislative, legislative power of the National Assembly. In other words, what it says is that until the legislative process is, in other words, when it's a bill, to put it simplistically, you can't challenge a bill. That's what it says. Because we all know why you can't challenge a bill. Because it's not an act. It's not. That's all that Clenista. It's got nothing to do with what we're discussing here. Clenista is about that. So and in any event, Clenista is also an earlier decision. I'm saying
It's been overtaken by
and that line of cases. So Clenista, JT Publishing, what have you? All those cases predate the Gijima principle. ASLA is the court case you must look at, which is where that case, well, we must look at Gijima itself, obviously, but ASLA is where it was applied and explained in the terms that I've just explained now, paragraphs 61, 66, 67, 68. All right. So okay. This is the point I was making, that because of the misapplication of a technicality called in medias res, which I said I'm prepared to concede for the purposes of today. Let's assume that court was correct about in medias res, but that cannot entitle it not to address the real violation of Constitution, justice. That's why we always talk about the interest of justice. Justice. That's what we wanted there. We didn't get it. That's what we want here. And the reason we didn't get the justice there was because of that technicality. Now here it is, I don't even know what to call it. But there's a whole argument that we must not get justice here as well of that injustice. Why? Because of a technicality called substitution, which is now being opposed all of a sudden in this court. My learned friend, Mr. Jamie, addresses a matter which he has not opposed and is allowed to go on about the issue of substitution, which they had the right to oppose when we filed, and they elected not to. But now suddenly it's the big reason why we must be denied justice. Well, let me address it. The new technicality over the technicality of the Western Cape that is being raised here is completely has no place in these proceedings. There's Maposa, there's TechMed, there's a series of cases where Rule 15 was applied. Nobody has said why that rule was applied in those cases by this court, but in this case, suddenly it must not be applied. Right? And then the presiding judge this morning gives us a 2-page document to say on this Rule 15 issue. But that 2-page document, the only thing it does is to prove that Rule 15 applies here. Because if, what paragraph 25 of this Celia judgment, no, I told you that in chambers. We both told you.
I don't know whether that's the way in which you put it is to suggest that that's a criticism of me and my counsel.
No.
I was being of assistance to counsel and drawing to their attention an authority that they perhaps may not have been aware of as a result of their own researches. So and when I gave you this 2-page document, I said, I asked my secretary to assist, and it's not the full judgment, but I drew your attention to what I thought was the relevant paragraph of the judgment.
Yeah, for which we are grateful. I'm sure we said, if we didn't say it in chambers, we'll say it again. Thank you for that. Yes. And also, if we didn't say it in chambers, maybe we say it now in public. We were both not aware of we said it in chambers, but it might be important to repeat it here, okay? So I don't know where the criticism is. It's a compliment. I'm saying unless if the authority was being given to not to assist us. Because I'm saying I'm glad for the assistance. Thank you very much. Because it assists us in proving the point we are making. That paragraph 25, you would not have this, what is said here by, I don't know who the church was. But it said that as recorded above, notice of substitution in epistle capacity as the second appellant by the executives of her deceased estate was given in terms of Rule 15. And then it says, in so doing, Rule 15.2 was overlooked. That's all I'm saying. So that means Rule 15 applies to this court. That's all. And it says, if Rule 15 applies to this court, as this judgment, which you, thank you very much, gave to us, makes it very clear, then Rule 15 applies. So it's another, in the long line of Maposa, TechMed, and now we have armed with, thanks to Justice Bonan, with the Cilliers case to make that simple point, that Rule 15 applies here. Because if Rule 15 didn't apply here... Yes?
What it says is, it says, the first proviso to Rule 15, 2 was only.
Yes.
Which states that saying to the leave of court, granted on such terms as to it may seem meet, no such notice shall be given after the commencement of the hearing of any proposed matter.
Yes.
And then the judgment says, and this is the important bit, the leave of the court of law or the leave of this court was not sought prior to the filing of this notice in terms of Rule 15.
Exactly.
And then it says, absent an application to court for the substitution of the executors, the purported substitution is irregular.
Yes, exactly.
So you agree with all of that?
I agree 1,000%. But this shows exactly that A, Rule 15 applies. It shows B, that you cannot do it without a notice asking for the leave, which we did. And C, it shows that exactly, and it says in that court or this court, which means it applies. This court means the SCA. That means it applies here. Okay? Then thirdly, why would that judge say the proviso has been overlooked? You don't get to the proviso if Rule 15 doesn't apply. So this proves beyond any doubt.
So if we follow that decision, you'd be comfortable?
No, Judge Justice. You know, this is a serious matter where what we are saying is that if you follow the point I'm making, which is that this judgment proves that Rule 15 applies here, that's all. You must follow that.
It doesn't just apply in part, it applies in its entirety. Now, do you accept that this is a precedent that we are bound by?
Yes, as you are bound.
Are you suggesting that there is any basis to distinguish this authority on the facts of the present case?
But how could I do that? How could I say something is supporting me and want to distinguish it? What is that? How could I do that? I can't. If I'm bringing authority here, I say Asta or Kijima, and then I must also distinguish it and rely on it at the same time. No. I'm simply making the point, and I'm going to make it, that this judgment adds to the fact that the Rule 15 applies here. There's no debate about that. It's true that it then says, in that particular case, or whatever, Rule 15.2 was overlooked. But I'm saying even that statement proves that Rule 15 applies, because you wouldn't apply the proviso if the rule itself didn't apply. Okay. So, and then the court, this is where the distinguishing factor is. It says there was no application before this court. In this case, there is a Rule 15 notice. Okay? So that's the issue. The second issue, which also makes it clear that Rule 15 applies and is not discretionary, as was postulated, is the wording of Rule 15.1. Right? Rule 15.1 is couched in peremptory terms.
When I spoke about the discretion, I spoke about the discretion in relation to situations where one doesn't merely file a notice in terms of Rule 15, but one is required as a litigant to file a substantive application for substitution.
Yes.
And in relation to that application, a court exercises a discretion in weighing up the potential prejudice to the respective.
Yes, but
that's the discretion that I spoke.
Yes, okay. Well, but we're not there. My learned friend, Mr. Jamie, said the only issue that we are at idem about is that we are not there. That Rule 15 was intended to avoid that application that you're talking about. The notice, in fact, that's what I was saying earlier in the morning. For the purposes of Rule 15, the notice is the application. It is the simplified version, because the drafters of this thought they should intervene in favor of those who want to. So that situation does not arise at all. So here we are in the world of Rule 15.1, which has no discretion. It says, no proceedings shall terminate solely by reason of the death, marriage, or other change of status of any party thereto, unless the cause of such proceedings is thereby extinguished. Very simple. Peremptory provision, no discretion. No proceedings shall terminate, which is what is being sought here because of that. So if we are going to, we can, it may have said no proceedings may, then there would be a discretion. So it's completely peremptory. Of course, in that other situation, which has nothing to do with this, where there would have been an application, it may or may not, I don't know whether there's a discretion in that situation. But in this situation that is before you, there's no discretion. It's a peremptory provision of Rule 15. Right. So what do we have? We have a peremptory provision, which you must apply, and we have a long line of cases, including the one we were given this morning, that prove that the rule applies here, contrary to what my learned friend was saying for both of them. My learned friend, Mr. Jamie, backtracked. At first he said it does apply, obviously, but when he thought there's an opportunity to backtrack, then he says, no, it doesn't. Rule 15 only applies in the High Court. That's not true. Because it says any proceedings, that includes these proceedings. The confusion is really simple. It is this thing about the commencement. The commencement does not mean, really. What Mr. Jamie is saying is, so Mr. Jamie is saying we should have brought the substitution application in the High Court. How can that be? So it means if you are doing it as a result of death, you must bring it before you die. So how could you have brought it in the court in March 2023 when there was the change of status had not occurred? But that's the kind of submission that is made here, that the application should have been brought before the change of status occurred. You are taken to the page 50 of the core bundle, and my learned friend says that we said the application is granted and paid with costs, including the costs of 3 counsel. Of course, that was what he forgets is to look at the date at the bottom. 27th June 2023. All right? There was no change of status that had occurred there. So she was indeed the public protector on that date. So how could she have said there when she was filing the notice of appeal, by the way, I'm changing my status as a clairvoyant because my status might change as a prophet. Now, that submission is just devoid of any substance, to be honest about it. And that is why we say the application is granted with costs, including the cost of tree counsel. Because we are saying, yes, Mr. Jamie is right. We are saying, at that stage, give us all the relief. But that doesn't stop us from coming here now and saying, although we put that we wanted all the 5 prayers in June 2023, we no longer can ask for prayer 4 now because of the reasons that we've discussed. Since when is that a crime? And Mr. Jamie, also, and I'm quite astounded by this because I know him to be better than this. But he reads the prayers and stops at prayer 4. He says that there's no distinction between the relief and the... But the only prayer he doesn't read is prayer 5, because that's the prayer that's completely against him. We don't do that. Because the prayer that he didn't read says, granting any further just equitable remedies in terms of Section 8 of PAJA, Section 38, we've discussed that, and or Section 172(1)(b). So that's the gist of this whole thing about the alternative causes of action. So you can't read all the prayers that don't relate to the alternative cause of action and leave out the one that does, because that's misleading the court, to be honest. So if there's an answer to prayer 5, then you must read prayer 5 and answer it. You can't just not read it. Okay. Then he says that I don't want to misquote him. Sorry. Yes. The founding affidavit, this entire application is based on the review, and the founding affidavit makes that clear, quote unquote. That is false. Let's go to paragraph 72.3 at page 29. Where we outline what we say the issues. It's paragraph 72. We say these are the questions that arise. One of them, forget the other ones, PAJA and what. Ought this honorable court, therefore, I'm reading at 72.3, declare their decision of those people to be invalid, unlawful, and or unconstitutional. And then, in case somebody doesn't know what we're talking about, we put in brackets, in terms of Section 81D, that would be PAJA, of PAJA, Section 38, and or Section 172(1)(a) of the Constitution. And we are told here that there is nowhere where we distinguish between those 3 things. 81D, which is PAJA, Section 38, which is Declaration of Rights, and 172(1)(a), which is a Declaration of Invalidity. How can that be said when the papers are here speaking for themselves? Then, in case this is not clear, you go to, I think it's volume 9, page 1633. This is now elementary pleadings to show that this is an alternative that's being asked for. Page 1633, that's in our replying affidavit, paragraph 176. Advocate Mkhwebane says, I reiterate that I have made out a case to demonstrate that my fundamental rights have been breached and must, underline the word must, be vindicated by means of a declaratory order. And here's the important part. Irrespective of the review grounds or cause of action. In other words, irrespective of the review cause of action, which I may lose, I am saying my fundamental rights have been breached and must be vindicated by a declaratory order. And somebody stands up here and says, these affidavits do not make it clear that there is a clear separation of an alternative cause of action pleaded in terms of 172.1a. When that section is mentioned by name, we can't do that. We can't. At least it should not be allowed. And there are many other places. I don't want to you could go to page 16, paragraph 29, page 420, paragraph 229, page 69. You'll find I'll just do one for the sake of saving time. Page 69 at 229 paragraph. We say, violations of fundamental rights, big heading, section 10 and 34. In this section, we deal separately with the alleged violations of my fundamental rights as enshrined in the Bill of Rights, with specific emphasis on my rights of dignity in terms of section 10 and access to justice in terms of section 34. These are self-standing grounds for the declaratory and appropriate relief sought specifically in terms of section 38 of the Constitution. In other words, even if it were to be found that the Paja grounds or principle of legality was unsuccessful, this Honourable Court will still be called upon to grant the relief sought to any other appropriate, just and equitable relief, that's 172.1b, in terms of section 38, alternatively in terms of 172.1b thereof. I mean, as I say, there are hundreds of other examples, but for somebody to stand here and say these affidavits do not say that do not make it clear that we are dealing with a completely different animal is just unfortunate, I think, to put it mildly. Now, it's very clear from paragraph 5 of the notice of motion, it's very clear from the passages that I've read that there's an alternative cause of action which was ignored. Then there's this thing about the attorneys. This is a complete misunderstanding of what has happened here. This is what has happened. The other side, as they are entitled to do, invoke Rule 5. I'll paraphrase what that means. What that means is that the rule is very clear. It says, just to paraphrase, if the other side disputes the authority of your attorney, then you must put a power of attorney. Fair enough. Same as Rule 7 of the Uniform Rules. Now, what do? They say, you've launched an appeal under the name of the Public Protector. And we want you to show us that the Public Protector has authorized attorneys to act on your behalf in that. Fair enough. We then come back and say, oh, you are right, dear opponents. We don't act for the Public protector, and but we do act for Advocate Mkhwebane, right? And how do we show that we act for Advocate Mkhwebane? Here is a notice in terms of Rule 15 for the substitution of the public protector, that you want to protect the public purse and what have you. Here's a notice so that now she's standing up on her own 2 feet to say, I'm now here as myself. If there are any costs, there'll be costs against me. So the public purse is saved, thank God. Right? Now, if the opponents wanted to invoke Rule 5, then they should issue, once that has happened, because there's now a substitute, that party in respect of which the Rule 5 was being invoked has disappeared out of the scene. All right? And if they wanted to question the authority of Ms. Mkhwebane now as herself, they should issue another Rule 5 and say, Ramushu, Twala. No, that's exactly what the rule says. Let's go together. Yes, no, let's go to it together. Where's the volume 1? Sorry, Justice Bennett. Oh, I'm sorry. Yeah, let's read it together. It's Supreme Court of Appeal, Rule 5. Right. Rule 5.1, let's start there. Okay? It says, as is the equivalent of Rule 7, a power of attorney need not be filed. Right? That's the operational thing of them. But, so the statement is that a power of attorney need not be filed. Right. But the authority of a legal practitioner to act on behalf of any party, and any party in this case, let's say, is Advocate Mkhwebane, within I've just accepted that. I've said that when they did the first Rule 5, no. Well, you stopped me midway, so let's deal with it, with the issue that you've raised.
Who was that attorney acting for
At that time is what I've already said 5 minutes ago. They were entitled, perfectly entitled, to protect the public purse by asking for that attorney. I've said that twice now, that they were perfectly entitled to do so, and to question the attorney in defense of the public purse. But I'm saying, once it was then clarified to them that she's no longer acting for the so-called public purse, she's now acting for she now has attorneys who are acting for her as a human being, like you and I and everyone else. Then this is what happens. It says, after it has come to notice to any other party so acting, that's them, or with the leave of the court on good cause shown at any time before judgment, be disputed. In other words, if they now wanted to dispute Ms. Advocate Mkhwebane's the power of her attorney to act for her.
This is a dispute that pertains to the authority of the attorney.
Yes.
It has nothing to do with her.
No.
Let's read the rest of the rule.
No. When it says the attorney of any party, the party means her. Okay? So
And whose authority is being disputed?
of her attorney now.
There wasn't that time.
No. I'll do it slowly again. At that time, when the first Rule 5 notice was issued, it was perfectly great, legitimate, in protection of our tax. All right? That then happened. Then what then she did was to indicate, to say, I am not acting as the public protector. So you don't need the authority of Ms. Galeka, I think is the public protector now, for that. Because if she was insisting and say, forget it, I don't care what you say, I might have been impeached or not impeached, but because I was the public protector when the calamity happened, I'm still, if she was taking that position, then you would have to either get a letter from Ms. Galeka authorizing her to do so, or the power of attorney. But she's not saying that. She's saying, I relinquish that status. I'm throwing it away. And I'm now coming to this court as any other citizen. Now, they were entitled to say, well, even as that citizen, we want to invoke Rule 5 because we don't believe that your attorney has a power. And then that attorney would have included the or did the power of attorney. Anyway, that's really what the rules say. So, okay.
Unless a power of attorney is lodged with the registrar within that period.
Yes.
That's the rule operates. Absent a power of attorney on behalf of the party who is properly before the court, it operates to disqualify the attorney from acting.
Who is the party? The party is the public protector.
At that stage, who was the party?
It was the public protector. Is that party here now? No. So how could?
So that's precisely the point.
Yes, but honestly, this thing is very, very simple. It says that if in other words, two things can happen, Justice Pona. If you invoke Rule 5, the other side can say, "Oh, you got us now," and that is the end of the matter. Or it can say, "Here is the power of attorney." That should be patently obvious. So those are the two things that can happen. So if this other party was just a fly-by-night chance taker, that will be the end. We'll never hear from them again after the Rule 5 notice has been invoked. But if it is not a fly-by-night party, it will then file a Rule 5 power of attorney. This party before you does not say any of those two things. Firstly, it's not saying, no, I insist. It says, throws in the towel, so to speak, and says the authority of the public protector is non-existent. So I can't give you something that I don't have. And for that reason, the party called the public protector gets out of the window because of the failure to give the power of attorney. That could have been the end of the matter, but it was not. Ms. Mkhwebane files a Rule 15 to say, I accept that the public protector is gone, but I want to be substituted, all right? Substituted as myself into that position. Anyway, that's... Right, this is 15.1.
Yes. Advocate Mkhwebane was automatically substituted as the appellant in the matter, and there's no need for an application. So the leave of the court was never sought. I'm confused by the document because it says notice of application. So is there an application that this court is according to was entertained, or this was a notice to say I'm telling you that I'm now substituting the appellant?
No. There should be no confusion. She was saying, Justice Masipa, that I am conceding, okay, that the public protector, qua public protector, can no longer be the appellant. What I'm doing, and that's what I'm saying, at that point she could have made that concession and gone home. But she says, no, I am applying to this court in terms of Rule 15.1 to be substituted. Substituted means to be put in the place of that. It's like in soccer. You substituted, to be substituted in the place of that person who has now died or gotten tired or broken an ankle if it was soccer. Okay? And that is, it can be that she takes the attitude that was sufficient. Then what have we been doing here all day? Because what we're doing here all day is to move that application, because that application can only be moved here, which is unopposed, by the way. So if we took the attitude that by simply putting the notice, what's the problem? Then what would we have been doing here all day? All this day, we've been moving the unopposed application to substitute Advocate Mkhwebane for the public protector, which I don't understand what the problem is about that.
So if that's the position, then how would they have already filed a second Rule 5 notice?
No, because they would say that you are now saying, let's say it was someone who had died. You are now saying your father or your mother has died, and you, the son, and now must be substituted to be the appellant, right? Now, we have reason to believe that even you, the son, are not a properly authorized. And if they did that, they have to then issue a Rule 5, and then me, the son, I will then give them my attorney's power of attorney. It's that simple. So okay. Anyway, or alternatively, they could say, Justice Masipa, no, we are opposing your application. As they would if it was an amendment application. And then we know what would happen. But they don't do any of that. They don't oppose the application stroke notice of 15.1, and they don't contest the authority of the attorneys insofar as they are acting for Justice Mkhwebane, for Advocate Mkhwebane. Finish and clear. Okay. Now, yes, there is. Okay. Now, my learned friend for the DA says that it's not the ASLA Gijima law doesn't apply because the transgressions are not clear-cut and so on. I honestly don't think I need to address that. I can just make this point, which will make it easier, shortcut, which was presented to me by Justice Mutle. If you go to that rule, paragraph 47, Justice Mutle, that we spoke about, which is the justification really for the entire judgment, and you picked it out correctly. What is wrong with that judgment is that, as I said, it elides actively, if I may put it that strongly, the real complaints of what we're saying were the violations. So, for example, it says we don't know why she's not she's complaining about the temporary absence of her lawyers, because after that a postponement was given. That, even if that were true, that only applies to the closing out of the lawyers on the 13th of September. They don't say anything I mean, I don't know how wrong you can be. More than, they say nothing about the closing down out of the lawyers on the 1st of November, closing down of the lawyers on the 2nd of November, and the leading of a crucial witness in those days in the absence of lawyers. So how anybody can come here and say that the violations are not, don't speak for themselves. Secondly, then there is the Dube situation. I don't want to go through that again. There is a situation where one of the people is married to the initiator. The only thing you get, they say, no, she's not a complainant.
Haven't you covered all of this in your earlier address?
No, I haven't. I'm saying that the people were allowed to stand here and say that the violations are not as I'm describing them, and therefore the Gijima principle doesn't apply. So I have a duty to my client to reply to that.
Fair enough, but not to cover argument that you had addressed in your main address. In
No,
other words,
that's exactly what I'm not doing.
if you just focus on a reply to what was raised, the submissions that were raised, without necessarily repeating what you had said earlier.
Well, I can't do that. I'm unable to do that. I don't know how to reply without replying, without saying why it's wrong what they said. Yes. Maybe I don't understand the request. The only way I can reply to what they were saying is to demonstrate that they are wrong, and I was busy doing that. All right. Now, I was saying and I did this deliberately, as I said. I could have stood here and give you the 17 violations. I think 14 for the chairperson and 3 for Mr. Mileham. But I decided that it would not be necessary to do that. I'll use one of each. And all I'm saying is that even if you take it at that level of the one of each, the closing out of the lawyers and the patent conflict of interest, no one should be allowed to stand here and say that the violations in a constitutional state don't speak for themselves. I mean, what must happen? People must be shot between the eyes for it to be a violation of the Constitution. That's all she's saying. Ms. Mkhwebane is simply saying my rights were violated at that point, as Justice Krichler put it, at the source of the violation. That's how he puts it in the Forze case. Now, if we accept that submission was completely wrong and not supported by anything in front of you, then we are in the heartland of the Gijima principle. That's really the only point I'm making. That if we accept that, because that's what Gijima says, it says if the violations are as patent and glaring and clear-cut as in this case, then you can't deny the applicant of their rights. And I want to go further to say you can't do it on a technicality, whether that technicality is mootness, whether it's ripeness, whether it's delay, whether it's substitution for that matter. You can't, that's the gist of what the Gijima principle is. Then, finally, my learned friend doesn't, again, says something that's startling. Section 15.1 is there to invoke the 173 powers of this court, right? The inherent jurisdiction, and I think to his credit, Mr. Jamie acknowledges that. But in the same breath, he says that doesn't apply to this court. How can that be? Section 173 states that it applies to this court, of the Constitution at least. Sorry. Yeah. Just in case there's any debate, it says 173, the Constitutional Court, the Supreme Court of Appeal, that's here, and the High Court of South Africa, each has the inherent jurisdiction to protect and regulate their own process and to develop the common law taking into account the interests of justice. So, to the extent that the powers in 15.1, which Erasmus says, are a mere codification, if you like, of the Section 173 powers, of the inherent powers, and the simplification, because Erasmus says that that rule does two things. It asserts the inherent power and it simplifies the process. To that extent, then surely it must apply to the High Court, the Supreme Court of Appeal, and the Constitutional Court. That's so you can't again stand here and say that Rule 15.1 doesn't apply. Yes, it is part of inherent jurisdiction, but it only applies to the High Court. Where does that come from? Because the inherent jurisdiction now is no longer encapsulated in the common law. It's encapsulated in Section 173, which mentions this court by name. Yes. And it all really comes down to one final submission, which is this, that when the Constitutional Court says that this court, or any court for that matter, can overlook all these technicalities, whenever it is called upon to perform its most glorious duty, which is to vindicate the Constitution and to assert the rights, human rights of persons who come here. That cannot be something that that court said lightly. It can't be. Because as lawyers, when you read it, it almost offends your sense. How can you be allowed to get away with undue delay, mootness, ripeness, and all these things? But that court made that statement with its eyes wide open, so that men and women who want to assert their constitutional rights and use the Constitution as their shield instead of self-help or violence or all sorts of things, their path to doing so must be opened up as wide as humanly possible. And that's why that came from the Constitutional Court now, recently, but it came from the drafters of our Constitution in 1996, by the sheer expedient of using the word must. That's what they wanted to achieve. And to the extent that there was any doubt, that doubt has now been removed in Gijima, in Asla, in Notyawela, and a long line of cases. So that justice must be done, and a person must be allowed to vindicate their constitutional rights. Not a myriad of technicalities thrown left, right, and center and upside down, in medias res, mootness, substitution, this and that. That's exactly what that line of cases say should not be done, justices. Sorry, just one thing about the cost thing. I don't have to address that because I think Justice Ponan has addressed it correctly, except to just make the point that you can't have a circuitous argument that says don't substitute but mulct with costs. Secondly, it goes again to Justice Masipa's question. The concession, quote unquote, or the throwing of the towel to say this is not the public protector that is here, ipso facto means that Advocate Mkhwebane, as the substituted party, the cost must be against her personally anyway, because she's the only person who is before you. So there's no question about the so-called cross appeal. There's no one else who can bear the cost of this appeal except Advocate Mkhwebane in her personal capacity, because that's what she has asked you to do by substituting her. We're indebted to the court, and the relief we seek is therefore that, we leave that issue of the discussion in the hands of the court as to whether the matter, if the appeal is successful, will be remitted back to the Western Cape High Court or decided here. But let me just say that the reason the record, the full record, was included in the record was so that to give the court both options. So if the court accepts at face value, as it should, in our respectful submission, that the violations occurred, then there's nothing stopping this court from saying that if the violations occurred, if they were ignored, if they were pleaded and they were ignored, therefore the court must vindicate them. There would be no need to go back to the Western Cape High Court in that scenario. But if the court says, no, we're not inclined to do that, despite the fact that it will cost money and inconvenience and all sorts of things to go back to the Western Cape, we want you to go there, that's another approach. So the matter will either end here, go back to the Western Cape, or go to the Constitutional Court, whichever way. But we plead with this court humbly that the correct, in these glaring circumstances, the correct order would be to make the declarations that are requested in terms of 172(1)(a), because there's nothing. It will never change. You can take it back to the Constitutional Court, you can take it to the Western Cape, you can take it to the Magistrates Court, you can take it anywhere. The violations have already occurred. The lawyers have already been locked out. The conflicted person, Mr. Milham, has already sat and made a decision in conditions such as those in S versus Dube. So there's no purpose that can be served by remitting this matter back to the Western Cape High Court on these facts, at least. As the court pleases.